The above discussion, this court, considering the facts and circumstances under which the petitioner was arrested, finds that the petitioner is entitled to claim the immunity under the provision of Section 64A of the NDPS Act, and therefore the order dated 23/2/2024 passed by the learned special judge NDPS Pasikat is quashed and set aside in respect of the innocent petitioner. The criminal revision petition is allowed.
Obliged.
Obliged. Lordship, I want to mention I have filed one to AB bail application, urgent matter. So I will allow to her today. It's urgent matter. Police is chasing on me to so I have
You
no
have
option.
already filed.
Yeah, already filed. Two. Thank
Your Lordship, I beg to mention to move the unlisted matter, Your Lordship. It's an IA, Your Lordship.
IA for?
For this, yesterday, main case was fixed yesterday, but in that prayer portion, we miss out this one, prayer for staying of the trial, Your Lordship. Quashing application that was fixed yesterday, Your Lordship.
Okay, let's see.
May I please, Your Lordship? Your Lordship, I would mention that today I filed one IA regarding the modification of the order passed by this honorable court on 9/4/2025.
Modification.
Yes. So that matter may be taken up to date.
May I please, Lordship? Lordship, this is the petitioners herein are family members, and they have filed this joint petition, criminal petition for setting aside and quashing of charge sheet number 09 of 2023, arising out of ROWPS case number 12 of 2023, Your Lordship. The case is currently pending trial before the learned Chief Judicial Magistrate Alo.
The usual settlement. You have,
Yes.
You have executed settlement.
Yes, Lordship, we have done that already.
Where is that?
At page number 40, Lordship. Annexure
Annexure
4, page
4.
40, yeah.
Annexure 4. These instructions.
Yes, my lord, the record may be called for, and your lordship,
Yes,
only two sections are non-compoundable. That is 212, which was not initially registered, but later on during the filing of the charge sheet, 212 was included. And the other section is, my lord, it's 458. The two sections are.
The record, but anyway, Supreme Court also says in such cases.
Yes, yes,
When
absolutely.
it's between
Yes.
family members.
Yes,
and
because the
not
offense
against-
is not against the society
Not
as well.
against the society,
Yes, no.
you know. Anyway. This is an application under section 528 of the BNSS 2023 for quashing and setting aside of charge sheet number 9 of 2023 under section 427/458/342/325/212 of the IPC arising out of ALO WPS case number 12/2023 in GR number 49 of 2023, which is pending trial before the learned Chief Judicial Magistrate, Alos, West Siang District. Stop. It is stated that the accused and the victim have entered into a settlement, settlement dated 28th day of March 2025 at Itanagar. And therefore, it is prayed that the charge sheet and the case pending trial before the learned Chief Judicial Magistrate Alo West Siam District may be quashed and set aside. Stop. Learned additional PP, TAT, interest appearance on behalf of the respondents. So no formal notice called for.
Lordship, one prayer. Pending disposal of this instant petition, the proceeding before the ALO court may be, CGM court may be stayed. Page 13, Lordship.
Anyway, that will come at the end. Call for the record, scanned copy of records from the court of CGM Alo West Siam District. Stop. List the matter of the 4 weeks. Stop. Pending disposal of the present petition, the proceedings of the GR case number 49 of 2023 before the court of CGM Alo West Siam District will remain suspended.
Obliged, Your Lordship.
Deeply obliged.
It's the huge judgment on order dated 17/2025, whereby matters accused have been sentenced to 3 years jail. As on today, the accused has been granted bail, here on the bail. Court is present the appeal by the trial. But let's see this entire records, madam, from the case records. That the basis on which this conviction has been done is only on the basis of the oral statement. Let me have the record that there is no material evidence supporting the oral statement. Now, even if you see all the oral statement of the PW 1 to 3, my lord, but we find there is a material contradiction in the prosecution evidence. But all those aspects definitely will be good for during the hearing of the main case. But otherwise, my lord, a very good case, my lord. So far, this case is concerned, my lord. So, my lord, this accused person, this appellants, my lord, they are in 8 numbers, my lord. They are from the same plant, and it is also admitted on the record that there is a land dispute, long land dispute is between this the complainant party and the accused party. So there's every possibility that this case has been falsely projected and improvised during the trial also. Now, see this accused number. Accused appellant number 1 is the father, and appellant number A and 6 is the son. The appellant number 1 is 65 years old. Appellant number 8 is 85 years old. They are from the same family. Then other appellant number 2, he has 5 children. Appellant number 3, 4 children, 5, 6. Appellant number 6, 2 young son. Appellant number 3, young son. Considering this aspect, since so from I am praying, since they are already in bail, so that in the meantime, they may be allowed to remain on the same bail, and case report can be called for, and whether can be heard. This is a punishment given after 3 years. They are taking the interim order, order of the granting bail, Case
What is the bail?
Case 14 of my appeal, Page 46, annexed to 47, see. The convict shall be released from the judicial custody, so and so, so and so, so and so.
This,
IA by process.
where is it?
36 I. Suspension of this item.
bail is already there, so that they can continue.
Already granted within trial court, madam, that's why there will be a lot of criticism. That is to enable me to present.
Yes, BP, any objections?
Lordship, my only submission that Lordship, as per the section 336 Lordship, that is the punishment is Lordship 10 years and above, and more leniency has already been granted for the 3 years. Looking towards that the all and the age factor Lordship, they have already leniency granted. So
That we'll examine later. That
Yes,
we'll
Lordship.
examine later. I'm only talking about the suspension.
the officer bail is already granted, then Lordship is up to the Lordship, this honorable court.
No, but the trial will continue, no? Then
Yes, Lordship.
No, madam, trial is over, madam.
Oh,
That's over,
convicted,
Lordship.
convicted.
Convicted,
Then
Lordship.
what's the need for suspension now? And if they're on bail?
That's bail, they are in bail, madam.
So,
Whether
so no
I-
harm will be caused even if it is not suspended.
No, suspension is not required, madam. That
Not
in the
required.
meantime, madam.
Bail will continue.
Continue to remain.
Yes, no problem. This is an appeal under section 4152 of the CRPC 1973 for setting aside and quashing of impugned judgment and order dated 13/3/2025, passed by the learned session court 0 in session case number 4/2017 under bracket Z, big Z, corresponding to Sangram Police case number 7 of 2017, convicting the appellants under section 436/34 of the IPC and the sentencing order dated 17/3/2025, sentencing the appellants to undergo 3 years of simple imprisonment and payment of fine of 2,000 under section 436/34 of the IPC, and with a default clause to undergo SI for 3 months. Stop. The learned additional PP has accepted notice on behalf of the state respondents. Number 1, the appellant shall take steps for service on the respondent. Number 2, by registered posts with AD within 3 working days from today. Call for scanned copies of the records of session case number 4/2017 on the bracket Z from the court of session judge. Which session judge?
0.
The session judge 0. It has been stated that the appellants had been granted bail by the learned trial court by order dated 17/3/2025. Accordingly, the bail so granted may be allowed to continue pending disposal of this appeal. List a matter after 4 weeks.
Of license.
No, my lord, it has allowed to remain.
Yes, yes. The IA will be closed.
Of license.
IA, okay, 36. Yeah. In view of the order passed in the criminal appeal 7 of 2025, IA 36 of 2025 is disposed of.
Of license.
Your Honor, Lordship, this is bail application number 30 of 25. Here, Your Honor, the alleged accused person was arrested in connection with the Dumpurjo police case number 01 of 25. And charge was under 103 of subsection 1 of BNS. The filing of this bail application, Lordship, during the time of CD calling, that it was learned that the case has already been charged. So on last occasion, TCR was called. So accordingly, as per the TCR, Lordship, the charge has been altered from murder to culpable homicide. Previously, it was 103 subsection 1 for murder. Now it's 105 for culpable homicide. As we can see in the charge sheet, the investigation officer, while investigating the case, has found out that as per the, it is in the last third para of the charge sheet.
Yes.
Page last third para. Here, the IO has find out that as per the PMA report, the cause of death is intracranial hemorrhage or brain bleeding, which indicates that deceased had sustained internal brain injury. However, the punching act of accused was sudden and under the influence of alcohol. Deceased had succumbed to internal injury of brain bleeding after 3 days of quarrel due to negligence of not getting treatment, which amounts to culpable homicide, not amounting to murder. As such, the intention of committing murder is not found against the alleged person. This was the finding. So accordingly, the charge has been dropped from 103 subsection 1 BNS to 105 of BNS. So, Your Honor, the case has already been committed to the trial court from Chief Judicial Magistrate, Upper Subansiri District to Additional Sessions Court, Basar, Laparada District. So the case is fixed on 21 April for appearance of the alleged person. Lordship, here in this case, Your Lordship, the case has already been charged sheeted. When the case has already been charged sheeted, further detention of alleged person in custody does not serve any purpose. The main purpose was to investigate the case. Secondly, whether there is chances of alleged person from absconding the trial. Lordship, in this case, the applicant, the alleged person is a permanent resident of Upper Subansiri District, having his family, entire family within the jurisdiction of Upper Subansiri District, and his entire inherited properties, whether movable or immovable, it's all under Upper Subansiri District. So, and moreover, his families are also there. He is having 2 kids, 2 minor kids. One is 4 years old and one is 1.5 years old. So, leaving all those, there is no any question of absconding from Upper Subansiri District, Lordship. So, there is no any chances of alleged person to abscond from the trial. Apart from that, Lordship, the alleged person is innocent in this case. There was no any intention to cause death of his beloved wife. It was all because that under the influence of alcohol, they had some quarrel on petty issues with regard to their domestic problem. For that reason, they had some altercation. During that, they had some physical exchange also. So for that reason, the deceased had succumbed to her injury after 2-3 days. And when the deceased was suffering, then alleged person, he took deceased to the hospital for her treatment. Even he was ready to evacuate deceased from district hospital Dapurisha to TRIMS Naharlagan for her better treatment as per the referral of the concerned doctor of Upper Subansiri District. But unfortunately, before she could be evacuated to TRIMS Naharlagan, the deceased succumbed to her injury. So there was no any intention of alleged person to commit such offense. Lordship, the alleged person is a first-time offender. There is no any such offense committed by alleged person. Apart from that, neither there is any pending case before any trial court. Lordship, there is this is the first case that the alleged person is facing, and that too which he has not intended. Lordship, apart from that, now the alleged person had 2 sons from the deceased wife. One is 3 years, 3.5, and another is 1.5. Now, when the disease has already expired, now there is no one to look after the two infants. It is the eligible person who has to look for them. As of now, the children are under the custody of the father of eligible person. So it is very much important for eligible person to come out from the custody and to take care of his two infant children. And
Lordship, my submission that Lordship, the managers, this offense is serious in nature, and the victim before her death has fully narrated the story that been beaten by the accused to her brother, and that is the complainant, Lordship. And Lordship, my only fear that till the recording of the deposition of complaint before this before the trial court may not be granted, so to avoid the tampering of the evidence. That much, Lordship.
Lordship, I have one citation on which I want to rely.
Actually, the only ground which was given by the learned trial court in dismissing his bail was that the injury, that the victim succumbed to an injury, and they're having chances of tampering with the evidence by the accused person. This court is not inclined.
Yes,
So now
Lordship.
that it's already charged sheeted,
Already charged sheeted.
now there's no question of tampering with the evidence. And he's got minor children also, so
Mm.
definitely.
Then Lordship, if Lordship inclined to grant bail, then strict condition may be imposed, Lordship.
Yes, definitely. And he's got landed property. It's okay. This bail application has been filed under section 483 of the BNSS in respect of the accused Taji Nalo in connection with Tumpurijo Police Station Case number 1 of 2025. During the pendency of this bail application, it has been found that the case has already been charge sheeted, and accordingly, the trial court records had been called for. As the result, the trial court records are before this court, and the charge sheet has been perused, and it is found that the registered section 1031 of BNS has been converted to section 105 of BNS for committing culpable homicide not amounting to murder. Stop. It is stated that the matter is now fixed for
First appearance,
charge on
21 April.
21st of April 2025. It's fixed for CC, na?
It will be for appearance, since trial court is at different district, committed
Oh.
from different district.
Acha, acha, acha.
So
Okay.
there is.
So just for appearance only. So it has been fixed for appearance of the accused on 21 April 2025 before
ADS Basar. ADS
before
additional.
additional session judge Basar.
Yes.
So he may be appear before Lordship to the court for the statement, Lordship, on that day. He will appear in the court.
Yes. During that time he will appear.
Yes, yes.
His direction may be given, Lordship. Otherwise, Lordship,
If-
sometime what
yes,
happened, bail
yes,
granted
yes.
and.
He will definitely comply.
He has to appear. 21-4, na?
21-4.
21-4. Before additional session judge Basar. The stop next paragraph. Learned counsel for the petitioner, Sri such and such, has submitted that the accused person is a permanent resident of Upper Subansiri district with landed property, and therefore, even if the bail is granted, there is no chance that he will abscond. Stop. He has also stated that after the demise of his wife, of his victim wife, comma, he has 2 minor children to look after. And moreover, he has no criminal antecedents. Stop. The learned counsel for the accused slash petitioner also states that the matter is now charge sheeted and therefore there is no chances of him tampering with the evidence. Stop. Accordingly, it is prayed that the accused may be granted bail in the present case. Stop. Next paragraph. Learned PP L. Hage, appearing for the state respondent, has objected to the bail application, stating that the offense is serious in nature and if bail is granted, no, don't say that. That the offense is serious in nature and that the evidence of
The recording of the
the
statement.
the recording of the statement, no, that is already all over now. Now only CC and then evidence will start.
Just my submission that lordship before the trial court, his deposition may be recorded. That is lordship.
Till the evidence is recorded. Just say till the evidence is recorded, the accused may not be granted bail. Stop. It is also stated that she has also submitted that stringent conditions may be imposed so that the accused person does not abscond
And tempering the evidence.
Stop. Or tamper with the evidence. Stop. Next paragraph. This court has considered the submissions of the opposing counsels and also perused the records available before the court. Stop. It is seen that the case is already charge sheeted and therefore the custodial interrogation of the accused person is no more required. Stop. The court has to only ensure that the accused presents himself before the trial court for the trial as and when summoned, and that he does not violate the conditions of the bail so granted. Stop. Next paragraph. This court is of the view that the accused can be allowed to be released on bail at this stage, considering the facts and circumstances on the following conditions. Number 1, the accused shall execute bail bond of 30,000 with one surety of like amount to the satisfaction of the learned trial court. So, number 2, the accused shall appear before the learned ADJ Basar on 21/4/2025 without fail. So, the accused shall not tamper with the evidence or try to influence the witnesses in any way. Stop.
Till completion of trial lordship.
Yes.
Till completion of the trial.
Till the completion of the trial. Stop. And next, if the petitioner, the accused shall not leave the jurisdiction of the trial court without leave from the court. It's with these observations, with these conditions, the petition is posted.
Right, lordship.
The trial court records may be returned back to the court.
Right.
May I please, your Lordship? Lordship, this anticipatory bail, Lordship will find the FIR at page 18, Lordship. Lordship will find that I am not named in the FIR, Lordship. Allegation is, Lordship, just reading out the FIR, Lordship. On 13 March 2025, at around 6:30 p.m., information was received regarding a case whereby some unknown individual had forged the signature of Deputy Commissioner East Coming and a sanction order with number so and so dated SEPA 11th March 2020 was taken out for carrying out one work, namely repair and maintenance of community hall at Laching Bagang village under Siang Tajo ADC East Coming district. I'd like to inform that Sri Himanshu Nigam ISDC East Coming has been on leave since so and so till date. Therefore, you are requested to register the FIR and initiate necessary action under relevant sections of law. The allegation is basically that the signature of the Deputy Commissioner has been forged in a sanction order.
For repair and maintenance of community hall.
That is the sanction order. Sanction order for this particular work. And in that sanction order, it is alleged that the signature has been forged. Now, here in Lordship, after registration of this FIR, two alleged accused has already been arrested, Lordship. One has been released on bail, and the main accused is behind the bar, is still in the police custody, and he has been interrogated and Lordship, my ground for granting anticipatory bail in this
Why
instant
you
application.
apprehending?
Lordship,
If you have nothing to do with this.
Lordship, police are behind me because I, being the friend of this particular main alleged accused who has been arrested, I used to use the vehicle on rent of the main alleged accused who has been arrested. And one or two occasions on good faith, without knowing that the documents which was given to me for giving it to several offices, I used to use his vehicle, Your Lordship. So on that simple ground, the police are behind me, Lordship.
Maybe you have instructions.
Yes, my lord. Yes, my lord. Your lordship, FIR, no one has mentioned, but your lordship, when sanction order has been forced, and sanction order is connected with many aspects, the monetary aspect of the state also. And your lordship, not only this bail I will come to the effect of this case, but other two two applications also, this accused is belong to this accused. So inference can be drawn that he is a habitual offender. And secondly, your lordship, why he is an apprehension? Because he is the mastermind behind it. Your lordship, this is the case diary, your lordship. Lordship.
These three petitions are arising out of different cases.
Yes,
Different FIR.
same accused.
In one district, SEPA, two FIR was registered, and Koloriang, one FIR was registered.
In the other two cases also forgery.
Yes,
Same.
same using forging the signature of the official authority, your lordship. Seal, stamp, everything.
Hmm. I don't think this petitioner will be allowed.
Lordship, the whole case is depending upon the documentary evidence, Lordship, is since its allegation
But
is of
at this
forgery.
stage, the court has to go by the Ayog's observation.
Yes, because this is anticipatory bail. If it is regular bail, then the situation would have been different. It's a privilege of pre-arrest bail.
Lordship, in my considered opinion, Lordship, since the entire case will be based on documentary evidence. His
The
arrest is
accused,
not
the
credible.
co-accused, this Bengia Mankum, confessed of his crime, that is forged signature of DC on the sanction order on the advice of Langkum Anand. The mastermind in the present case is such and such because he suggested the idea of procuring work to Bengia. Then you're always carrying around printer, laptop, and seals of different offices.
Yes, Your Lordship.
Fake sanction orders were provided to Bengia.
It's too early for Your Lordship, pre-arrest bail, Your Lordship.
But then, Lordship, my instruction is otherwise, Lordship.
Yes, it will always be
No,
otherwise.
no, no, they are always innocent, Your Lordship. They are always, accused are always innocent, Your
Yes,
Lordship, and
yes.
principal will always be there,
The
no doubt.
council will always be told that they are innocent. This is an application under section 482 of the BNS. It should be. No, no,
Yes.
it should be BNSS.
Again, mistake.
Again, here also cost title.
Yeah, Lordship, I
He's al-
corrected.
He's always in
I'll correct
penal
it.
provision.
Always using BNS instead of
No.
BNSS. I mean, we are all confused, but still. The application under 482 is right.
482 is correct, Your Lordship. It's for anticipatory bail.
Under section 482 of the BNSS, okay. Praying for the grant of pre-arrest bail to the applicant, Shri Langkung Anand, Langkung, Langkung Anand, in SEPA, no, just stop there. Stop. The learned counsel for the petitioner slash, no, here just say, yeah, petitioner, learned counsel for the petitioner, the such and such has submitted that this present bail, pre-arrest bail application has been filed apprehending arrest in connection with SEPA Police Station Case number 7/2025 under section 336 under bracket 3/338 of the BNS 2023. Stop. The learned counsel has stated that the applicant's name does not figure anywhere in the FIR dated 14th March 2025. The FIR was registered based on allegations related to fraudulent activities concerning public funds, wherein one Shri Bengia Mankum, Bengia Mangkum, Bengia Mankum, was arrested from Papunala in connection with what is KLG? In connection with KLG PS case number
Colorian, Your Lordship.
Color, KLG is color.
1/2025 under sections 336 under bracket 3/338 of the BNS. The present applicant also states that he was engaged in operating a vehicle that was owned by the accused Shri Bengia Mankum on rental basis. And he did not know anything about the unlawful activities being carried out by the accused Shri Bengia Mankum. So, accordingly, the applicant states that he is innocent and has been falsely implicated due to his association with the accused, and hence this present application. So, learned additional PP, it is submitted has produced the status report from the concerned IO. This court has produced the same, and it is seen that the accused Bengia Mankum has stated before the IO that he had forged the signature of the DC S. Cumming on the advice of the present applicant. The accused has also stated that the mastermind in the instant case is the present applicant Langkum Anand, because he suggested the idea of procuring work to the accused person. As per the statement of Bengia Mankum, the present applicant Lankum Anand is always carrying printer, laptop, and seals of different officers. And the fake sanction orders were provided to Bengia Mankum by the present applicant. And even the fake DC and even the fake seal of the DC is coming was made by the present applicant. So the IO has stated that the case is sensitive in nature and the investigation is ongoing as there is involvement of siphoning money from the state exchequer on the pretext of fake sanction orders. Stop. The IO has also observed that there may be many other persons involved in the instant case, and the nexus can only be uncovered if the present applicant Lankum Anand is arrested for custodial interrogation. Stop. Next paragraph. This court has considered the facts and circumstances of the case. Stop. It is seen that in the interest of justice, the present applicant is required for custodial interrogation. Moreover, when there are also many other cases of similar nature pending against the said applicant in different police stations. Stop. Dismissed, being bereft of merit. Same order, okay, in the other 5 and 6 also, only the
7 also,
station-
Your Lordship. 7
Oh,
also.
7 also.
6, 7 also.
Okay. Only the police station will be different and FIR will be different.
Yes. Obliged.
We'll take a break for 5 minutes because the unlisted matters haven't come, okay?
Concept may submit. Concept, this is the case relating in connection with Palin PS case number 08/2025, registered under section 109 clause 1 118 clause 2 3/3 clause 5 of BNS Act 2023. Concept, applicant here is a teacher by profession. This is relating to the case is relating to the informant file FIR relating this a place called Nyomi, which falls under Karadadi district.
So that same one.
Close. So here what happened actually on dated 23/3/25, the informant party again attempted the agriculture activity on the dispute land. The petitioner and his brother peacefully requested them to refrain from engaging in such activity, but the informant party, in violation of status quo, assaulted the petitioner. So here petitioner is a victim. On 26/3/25, Lordship, page number 4, para 7. Para 7. On that, para 7, on 26/3/25 at around 9:30 a.m., the prisoner once again peacefully approached the informant party to request maintenance of the status quo. While in the midst of the discussion to resolve the matter, that land dispute, Lordship, the petitioner was suddenly attacked with a sharp mastache by one Sri Tagru Taro Jakru and Sri Tagru Jakab of the informant party. He sustained grave injury on his right arm. That means petitioner was got injury on the right arm. In the meantime, the petitioner brother Sri Tagru Mai, who is also in petitioner in AB number 9 here, Tagru Mai came to his rescue, but was also attacked by Sri Tagru Tayo and sustained grievous injury on his left leg of the leg. That means petitioner number, this applicant AB number 8 was also injured in this case. And sustained grievous injury on his left leg of the leg. Thereafter, both lost consciousness and were taken to Gangte Health Center, that is under Karadadi district, and were later airlifted to RK Mission. Here, the petitioner was lifted to RK Mission, Itanagar, for further treatment. 8. The petitioner was later discharged from RK Mission Hospital on 26 on the same day, 3/25, and referred to St. Luke Hospital, Dibrugarh, Assam, for further treatment due to the severity of his injury. A copy of Lordship, that is in page number 24. Kindly Lordship turn to page number 24. If the RK Mission has one Tagru Anand, who is petitioner here, this RK Mission on the same day, on this incident same day, he was admitted at RK Mission, airlifted from place of occurrence to RK Mission. Again, and in the same evening, on same day, the petitioner, being a victim of the case, shifted to St. Luke Hospital, Dibrugarh, in the night itself. And thereafter, presently, the petitioner is under severe medical treatment at this Dibrugarh. And Lordship, here, the petitioner has not involved, rather he is the victim of this case. And Lordship, the injury mark I want to place before this court, the injury mark, Lordship, page number 35, Annexure E, the injury mark. The right arm was cut, injured due to the attack by the informant party. So this is the injury mark injured to the petitioner. And presently, Lordship, here, in page 38, here, kindly, Lordship, page 36. And medical certificate that issued by hospital management of St. Luke, Dibrugarh. This is to certify that patient name so-and-so, Tagru Mai, resident of Talikaradadi district, Papumpare, district, Arunachal Pradesh, and another patient, Tagru Anand, resident of, who is petitioner here in AV number 8. Tagru, resident of Chimpu district, Papumpare, Arunachal Pradesh, has been admitted for physical assault and undergoing treatment under general medicine and general surgery department, St. Luke Hospital, Dibrugarh. So this was issued by the medical DSD. So Lordship, here what my prayer is that since alleged accused person is victim in this case, and police basing on that FIR, that the randomly FIR that they filed, that taking the name of the person. So the police is now, as soon as I release from the Lordship, from the medicals, and they are going to arrest me any point. So being aggrieved and being victim of the incident, I may be I need the protection from the criminal court. Definitely, I'll cooperate the investigation and with strict terms and conditions, and fully I will cooperate and abide by this court order, and with bail bond maybe imposed as deemed fit and proper by this court also. Since the accused person, since petitioner is also Lordship.
You have updated case diary.
Lordship, the case study was called for, but it's a return back, Lordship. So no, yes, Lordship. Case study may be called for, Lordship.
We'll go for the case diary because there are many people involved here.
Right.
So the IO has to sift through the
Lord.
evidence against each person and then
Lord.
gives a report. No?
Plus, in the meantime, protection order may be given since they are really familiar in trauma, because the incident happened within the clan, the Tagru clan. They are very close family, so this may be civil nature and they'll resolve very soon. So I need the protection.
This is an application under section 482 of the BNSS filed by the applicant Tagru Anand. Tagru Anand. So it is stated that the petitioner is himself a victim of the said incident which occurred on 26/3/2025 at, what was that place?
Nyomi, Lord. Nyomi,
Yomi.
under Kradadi district.
In connection with Palin PS case number 8/2025, registered under sections 1091, 1182, 3, under bracket 5 of BNSS, read with section 27 under bracket 1 of the Arms Act 1959. He has submitted that the FIR has falsely alleged that the petitioner was one of the assailants. So, learned counsel for the petitioner also states that the petitioner sustained injuries during the incident on 26/3/25, where he had gone to request for peace and maintenance of status quo among the parties. Well, while in the midst of a discussion to resolve the matter, he was suddenly attacked by the informant party. Stop. It is also the submission of the learned counsel that the petitioner had to undergo treatment at RK Mission Hospital, Itanagar, and also at St. Luke's Hospital, Dibrugarh, Assam, due to the severity of his injuries. Stop. It is submitted that the petitioner may be allowed to recover from his injuries, and this court may ensure that he is not subjected to unjust arrest in a matter that arose due to a civil dispute. So, next paragraph. Learned PPL Tagi accepts notice on behalf of the state respondents. Call for the 10 copies of updated CD and list the matter on
From tomorrow onwards, court holiday
court holiday, so it can only be on 21st or 22nd.
23rd, Lordship.
27 on 23rd April 2025. So, in the interim, it is directed that in the event of arrest, the petitioner may be released on executing a bail bond of ₹30,000 to the satisfaction of the arresting authority. However, it is made clear that this interim protection will be subject to the outcome of the final hearing.
This board application 8 and 9. 9 is also same.
8 and 9.
9, yeah, same. Lordship.
9 also.
9 also same. They were together. The board petitioner.
9
Same.
also same order, but name will be different.
Lord. Highlight, please.
May it please your lordship. Lordship, this is I in regards to the praying for the staying of the trial which is pending in the before the Honorable Court of JMFC Khonsa, your lordship. So main case was fixed yesterday, your lordship, but inadvertently we forget to add
You
the
have not made the prayer.
yes, your lordship. Petitioner has made the payment, Your Lordship, already. No due is remain.
Not such a, that's 15 lakhs, 50,000 wala.
No, Lordship,
Yes.
this is criminal petition, Lordship. Yesterday only it has come, Lordship, the quashing of the FIR, Lordship.
No, this one.
Notice was
Criminal
issued,
petition 74.
yes,
Yes.
Lordship.
74 of 2025.
The order was in the page 9, Lordship. Or page 8 or 9, Lordship. Yesterday only this copy has issued, honorable court has issued notice, respondent number 2 and 3.
No, what the applicant stated was that the issue was regarding payment of 15 lakhs 50,000.
Yes, Your Lordship.
Whereas he has already paid the same and the complainant has also received.
But
That's
that
what he
we have
stated.
no record, Lordship, that his.
Yes, yes, of
I have,
course. The prima
next-
facie,
yes,
and
yes.
then he closed the copy of the receipt.
Yes, yes.
That on that ground notice was issued. So it's okay, we can stay, we can suspend this application, this IA 37 of 2025 has been filed by the applicant in criminal petition 74 AP 2025. Praying for suspension of the proceedings in FIR. No, praying proceedings, where's your FIR number and PS number?
FIR number 10, 2019, Your Lordship.
No, it was praying for quashing, sorry, praying for quashing of FIR registered at Dio Mali Police Station number 10 of 2019 under sections 120B/420 and 34 of the IPC and the proceedings thereof. So,
Lordship, Lordship, instead of the proceeding, Lordship, they have challenged, Lordship, prayer is there, Lordship, but their number is not there, Lordship.
that's why I'm looking for
Yes,
the
sir,
number because earlier in criminal petition 74, you had prayed for quashing of FIR, isn't it?
Quashing of FIR should not be granted, Lordship, because, Lordship, the investigation, Lordship, should be completed. If the charge sheet is, they have stated that
Then
charge
if
sheet
it's
already.
only FIR, then what proceeding to stay?
Wait,
No, Lordship, this is already charge sheeted, Your Lordship. I have annexed charge sheet.
but pending in which court, Lordship, they have not.
Pending where?
Annex 2 of main petition, Your Lordship.
No, but in
Annex
your
2,
IA, you have not stated anything. Which court?
With
or
a
where,
number, Lordship, there should be their number, something
And
should be
then,
like
and
that.
then the GR number, the case number, if it's already charged, sheet, there would be a case number before the court. Nothing is there.
Yes, Lordship.
We kindly withdraw this, this is incomplete. Because we cannot keep going to the main case, huh? See, number 1, see your para number 1. It only says praying for quashing of FIR.
Yes, Your Lordship.
So how court will stay the FIR? And then you have stated put up for motion, but that's all. And even in your prayer portion, you have only stated about the FIR number. This will not do. Otherwise, I'm going to dismiss it. You either withdraw.
Your Lordship,
withdraw-
actually the urgency is that this one, the petitioner, in the pending trial under this coming 22nd of this April, there is a matter listed on for this case.
They can come, Lordship.
You immediately withdraw it and refile it. Otherwise, I'm going to.
Your Lordship, since
It's incomplete.
the main payment has been done.
No, that is different. That is a different thing. You have not made any prayer. What do you want to do?
I will withdraw it and refile it, Your Lordship.
Counsel, the learned counsel for the petitioner is allowed to withdraw with liberty to file petition is disposed.
Blank.
Yeah. 11 also.
So,
Please, Your Lordship.
Yes.
Lordship, this is a IA application. Also kindly see the page number 16, Your Lordship.
16.
Yes.
This is a case when.
Has already watched and set aside the MPW issue by the Honorable Session Judge
Hmm.
on 9th of this month, Your Lordship.
Mm,
NBW was interfered, Your
That,
Lordship.
that non-billable one reference.
Yes, yes.
Yes.
Then what happens?
So thereafter, Lordship, I have submitted one application before the session judge and along with the order, Your Lordship. And the Honorable Session Judge has stated that there was no any direction of release of accused person. And there
There is no direction for?
release of the accused person
Oh,
because the accused is already in the custody, Your Lordship.
okay.
Otherwise, Your Lordship,
Okay.
the learned, actually, learned session court has, Your Lordship, misunderstood, Your Lordship.
Yes.
Here is section, para 10 is clearly says, the accused shall appear before the trial court. The accused will be appear when he is not in the custody. Otherwise, this honorable court ought to have directed to produce before the learned trial court. Since, Your Lordship, the NBW, basing on which he was arrested, again taken into
Because
custody.
NBW is already quashed.
Yes,
Huh. So, which means that you are at liberty.
yes.
Yes.
So
So
in this
you will
condition,
appear on 28/4.
yes, in this condition, I filed the petition before the session judge. May I kindly see the page number?
Session
20.
judge has not entertained his application on the ground that there is no any specific direction from the court.
Yes, yes.
That is the problem. This is the
It's understood. When the warrant is quashed, then it's understood.
I'm trying to explain that one to the session judge, but he did not listen to me, Your Lordship.
This is the difficulty with the.
So if this honorable court had modified some,
No, what can I do at this stage? What is your prayer?
It's a modify or clarify the order that is so and so, pass in so and so, to pass a necessary order for the release of the petitioner and allow him to continue on earlier bail.
And where is your application before the trial court?
is page number 20, Your Lordship.
Page
20,
20.
yes. On yesterday, I filed this application.
Your Lordship will find in the margin is written rejected by hand. Page 20.
Page 20.
Even no order has been passed in this application.
Where is it written?
20, Your Lordship, left side, Your Lordship will find handwritten. Left side in the margin, rejected. It was not even entertained, Your Lordship. The acting insubordination of this honorable
They have
court.
not understood. They have not understood you. The court have not understood the order. No order was also passed.
Yes, Your Lordship.
Application was in fact not entertained. Just simply rejected the.
Then we'll just put one line.
Yes, Your Lordship, one line. And what with the proviso yet that if he is not required in other case, Your Lordship. Yes.
Yes, yes.
This honorable court has just
The-
removed that paragraph 10, Your Lordship.
What happens?
This honorable court, Your
Yes.
Lordship, if this honorable court remove that line that the petitioner or accused person shall appear before the trial court on 28th of this month, Your Lordship.
He is actually in custody, Your Lordship, in other case also.
What happened in this case? Your Lordship,
Mm.
this honorable court, the session court has one more case is pending before the session judge, and on that day, Your Lordship, the
It was
another case was also,
same petitioner.
no,
Yes,
yes,
same
same
petition.
case person. So on that day, Your Lordship, when the matter was called, he
Mm.
was in the judicial custody. So subsequently, his bail on that case was also cancelled by
Was
the,
also cancelled.
yes, by the session judge. Your Lordship.
Everything has been done very mechanically, Your
Yes.
Lordship. It's already in
Without
judicial.
any application of mine, the people.
Yes, Your Lordship.
This application, this IA under section 528 BNSS has been filed by the petitioner slash accused Sri Asadul Ali, isn't it? Sri
Yes.
Asadul Ali and others. Praying for modification of order dated 4/9/4/2025 passed by this court in
Criminal petition 70 of 25.
criminal petition 70 of 2025. Stop. Learned counsel for the petitioner has stated that this court, by order dated 9/4/2025, had quashed the non-bailable warrant of arrest against the present petitioner, and therefore he had filed an application before the Learned Special Judge NDPS UPIA on, when did you file?
On 10,
On 10/4/2025. Praying for release of the accused person and to allow him to remain on his previous bail dated 30/10/2024. However, it is stated that the learned Special Judge NDPS UPIA has refused to entertain his application, and the same was rejected
Your
on the
Lordship,
same day.
application was not even entertained, Your
On
Lordship.
the same day, and the application was not even entertained. Stop. The petitioner has therefore prayed that the order dated 9/4/2025 may be modified to the extent that the special judge NTPS UPIA, isn't it? UPIA may be allowed to, should be directed to release the accused person and to allow him to remain on his previous bail. Stop. Next paragraph. Learned PP, learned additional PP appears for the state respondents and has no objection to the said prayer. Stop. At the outset, it is made clear that the quashing of non-bailable warrant of arrest would mean that the petitioner slash accused is to be released immediately. Stop. However, it appears that the learned Special Judge NDPS UPIA has failed to, no, has misunderstood the direction of this court. Accordingly,
Your Lordship, it should be used as a fail to understand, Your
has
Lordship.
failed, yes,
Yes.
has failed to understand the direction of this court and the import of the quashing of the non-bailable warrant of arrest. Okay. So, next paragraph. Accordingly, the learned Special Judge NTPS UPIA is directed to release the petitioner forthwith and to allow him to remain on the previous bail granted on
30 October 2024.
30/10/2024.
Your Lordship,
If the petitioner is, petitioner slash accused is not wanted in any other case,
yes, Your Lordship.
with the above modification, the petition is disposed of.
Obliged, much obliged. Your Lordship.